I will make a note that, under the parties of interest, the collective bargaining agreement refers to, quote, parties of interest. Following consultation with the council for the district, MSTA is a party of interest. The INEA has specifically asked the district to restrict activities of MSTA based upon INEA's grievance. I just wanted to make that clear that that did come from our legal consultation for the district. So at this time, if the board would like to take a break, we can do that, or we can continue. Okay. This time the board will deliberate, so whatever questions, comments you'd like to make, please go for it.
Dr. Earl?
Yes, sir.
Are there any other sponsors of meals during the 3-day new teacher academy?
Typically, no, and during my time, I don't believe we've ever had any other sponsor of a meal other than INEA or MSTA.
So, given that that's not the case, but would this contract prevent Benefits Direct, who is our benefits provider, from coming in and sponsoring a meal to make sure that they had an informational table and that made people aware of the HR benefits that they were?
Typically, we do not allow vendors to come in during New Teacher Academy. The reason we do that is because we do have our member benefits information that we get out. Now, if we had, I'll just use MCC, for example, somebody that was not a vendor that wished to come in and provide a meal, there would not be any problem with that. Actually, we would welcome that.
And the reason I ask that is because we've been focused on section 4.1a, but section 4.1b says that the association will be permitted to sponsor a breakfast and or lunch meal at the orientation as long as other employee groups are not excluded from sponsoring a meal during the orientation. To me, that's the piece that makes this all a moot point. That was a statement more than a question, but that's where I come from at this point. I guess my questions were leading up to that on whether or not somebody else wanted to sponsor it, if they could, and clearly in this case, MSTA is sponsoring a meal provided for under this particular case.
And that is correct. Like I said before, if we had a non-vendor who's trying to sell services that would want to sponsor, such as an MCC or, we have other partners, we'd certainly welcome them.
I would like to ask and just confirm, so in past years, MSTA has had a table at the new teacher orientation on the morning or day that they've sponsored a meal, is that correct?
This is my 15th year in the district, so 15 new teacher academies, at every single one, MSTA has sponsored some sort of either breakfast or lunch, and certainly always had an informational table. So this year was no different than in the past. Dr. Grant, would you agree to that?
Yes, I agree. Was INEA aware of MSTA having tables in prior years? And if so, did they ever make any comment that they were concerned or did not want that?
Certainly they'd be aware because INEA is there throughout the entire duration. So unless they would leave early, they would see MSTA is there. I don't remember in the past that they have ever expressed any concern.
I read through the CBA, it seems like there's a limited glossary of terms. I did not see the term, throughout the duration, nor interested party. Am I correct that those terms were not defined in the CBA?
I haven't looked for those specifically, but to my recollection, I don't believe that those are specifically defined.
Of course, I'm not an attorney, but, it's kind of like the armchair doctor, the armchair attorney here, looking up the term person of interest. Legally, it says a person or entity whose rights are involved and stands to gain from a lawsuit or petition, even though the plaintiff who filed suit is someone else. So I feel like on person of interest, I think that MSTA is legally a person of interest. As far as throughout the duration, I did try to find that particular legal phrase, and that is not a defined legal phrase. My impression is that throughout the duration feels like that you would have something that starts at the beginning and lasts all the way to the end. However, I'm not an attorney, and of course, different people can have different interpretations of words. That is just my interpretation. I feel like in an abundance of caution, the best thing to do in a situation where there might be confusion about language is for it to come up in negotiation if there needs to be additional clarity in that particular section.
And I would agree with that, Director Fears, and that is an option that I have presented to INEA, that they can bring this up during the bargaining process. That is the way in which any sort of legal document, such as a collective bargaining agreement, if there is a dispute through the bargaining process, that is the opportune time in which to bring up, as you would say, bring clarification to this. So throughout negotiations process, that would be the proper time.
Is it appropriate for INEA to speak to why they don't feel like that's inappropriate?
That's not part of this process.
I'm sorry.
just haven't gotten to that point yet. It wasn't something that came out last year during negotiations. Okay. I hope that answers your question.
Yeah, I guess I would just comment that it really is important to seek intention as opposed to interpretation. And so I know that when I have an intention and what my expectations are, I really define them. And so I feel like this does have room of interpretation because where it's possible there was intention on both sides to make this vague, so that there was room for it. I can't figure out, why there wasn't very clear, language used in this, to make it seem like, if that was the intent to not let anyone else be there, at all, why didn't we just say that in this agreement?
And that's part of my rationale for denying this, is because if the intent was to just say no one else could have an informational table at all, then that's what the CBA would have said. And it does not say that in this case.
In fact, what Greg read was kind of the opposite. Am I hearing that correctly? From B as opposed to A, yes. I would encourage it to take place in negotiations also. And maybe it did come up because it's just in the middle, we're here in the middle of that cycle. I don't know, but, the wording seems clear to me.
I'm sorry, someone's speaking.
No, go ahead.
Go ahead.
Jill, I'm sorry, can I cut you off?
No, you're fine. Go ahead.
Okay, maybe I asked this earlier, but maybe I can specify now, when this opportunity to do the regular process of negotiations was reiterated to INEA. If I'm missing something, why again was that not embraced? Why are we in this space? I feel like something's missing.
Well, the negotiation season hasn't opened yet, or the negotiation time of the year is not open. So when this came up, we were in the middle of that period of time between the years.
So it's
So-
time. Basically.
Well,
Not once in 20 minutes.
Yeah, you only have a certain time of the year to go through the negotiation with the district. So it's just not an arbitrary date that you can negotiate anytime something comes up that you don't like. So it has to be during that period, yeah.
So it makes sense that we either wait for negotiations or we hope that the board can say, hey, let's go ahead and make a change. It's making sense now, so maybe the idea is hopeful that we can hear this and say, okay, we recognize where this might be vague or unclear, let's make the change either one way or the other.
Well, the board doesn't have we don't make the change. That comes, we approve the changes if they're already after negotiations have gone through the system process.
10-4?
Yeah.
Okay, thanks.
Yeah.
Yeah, I was just gonna add that after listening to everything, and of course, we are the judges tonight. And we all have friends with both teacher unions. But after everything was said, I see no violation in the agreement. And so I'll be voting to support, Dr. Hurl's, decision.
Director or Vice President Roberson, is that a motion
That'd be a motion.
to deny or the grievance?
Yes.
Can you state that for the record?
I'll make a motion to deny the grievance.
I'll second.
It's been moved and seconded to, deny the grievance by INEA. Any further discussion? Ms. Miller, would you call the roll?
Eric Knapp,
Yes.
Mike Roberson,
Yes.
Carrie Dixon,
Yes.
Joe Eschery,
Yes.
Greg Finke,
Yes.
Denise Spears,
Yes.
Anthony J. Monday,
Yes.
That motion carries. Thank you all for your deliberation and your time on that.